Well, hello everyone, and welcome to Uncivil Law. Hope you're having a good day. We're here with a qualified immunity decision from our friends on the Fifth Circuit who have some thoughts they'd like to share with you. This just came down earlier in February. This is the case of Selena Marie Ramirez versus Jamirez Guadarramara. And in this case, the police tased a guy soaked in gasoline and set him on fire. And the court found qualified immunity. And I found this interesting. So I thought what we would do today is we would just read all the opinion. It's only 12 pages long, so it's not that long. So I thought, rather than save it for a batch record, what if we just did it live? We'll just do a live story on it. So yeah, we're just going to do like a batch release story, but we're going to do it live. Because why not? So let's get started with this. So we're going to read the tale of the tasing fire. All right. On July the 10th of 2017, Gabriel Anthony Olivius called 911 and reported that his father was threatening to kill himself and burn down their house. A family crisis. The father is planning to burn himself and the house. So we should call the police, which seems like a reasonable course of action, but how the police decide to deal with this makes you reconsider. Corporal Ray, Sergeant Jefferson, and officers Scott Elliott and Guadarramara of the Arlington Police Department responded. This would be Arlington, Texas, Fifth Circuit. Officer Guadarramara was first on the scene, and he began preparations while waiting backup. Preparations to set this guy on fire, I guess. Sergeant Jefferson and Officer Elliott were next to arrive, and the three of them proceeded to enter the house. Upon entering, Officer Guadarramara detected the odor of gasoline. A woman directed the officers to a corner bedroom on the east side of the house. There they found Gabriel Eduardo Olivius leaning against the wall and holding a red gas can. Okay, so what do the police know at this point? What did the police know? Let's put ourselves in the position of the police officer at the time. We're not going to fall into the trap of hindsight, right? We're going to put ourselves into the shoes of the officer at the time. Okay, so what does the officer know at the time? The officer knows that he's been called on a 911 call. He knows that this guy is threatening to harm himself and burn down the house. He can smell gasoline. He sees the guy holding a gas can. Right? So one would think that the thoughts of fire hazard might enter one's mind. You are smelling gasoline and see a gas can holding it, and that he's trying to burn down the house. Maybe this is a fire hazard, and maybe you should take steps accordingly. So what did the police decide to do with this information that they had access to at the time? After turning on his flashlight on Olivius, Officer Elliott allegedly shouted to Sergeant Jefferson and Officer Guadarramara, "If we tase him, it's going to light him on fire." Okay, so the officers have apparently drawn the right conclusion, and they have said it verbally. If we tase him, he's going to be on fire because of the gasoline that they can smell, and the gas can that they can see, and the knowledge of the threat from before. And somehow they managed to draw the reasonable conclusion. And I say somehow because we've seen some stuff in QI world, haven't we? And so the police drawing the reasonable conclusion isn't necessarily a given. But somehow these officers drew the right conclusion. They said, if we tase him, we're going to set him on fire. So we're not going to tase him, right? Okay. It was... Elliott then discharged his pepper spray into his face, temporarily blinding him, which is a reasonable course of action in this situation, one would imagine. It was at about this point, whether before or after being sprayed is not entirely clear from the record, that Olivius then doused himself in gasoline. So now they're watching him douse himself in gasoline. Now, maybe he was doused in gasoline already. It's not clear because they're smelling the gasoline. And it's not clear here where this gasoline is. So maybe he's already doused in gasoline and he's giving himself a refresher. But either way, the police see him pouring gasoline on himself. New information. They now know for a fact he's soaked in gasoline, assuming that was not a problem before. Guadalajara and Elliot, at least, and maybe Jefferson as well, noticed that Olivia was holding some object that appeared as though it might be a lighter. Guadalajara, genius, followed in short succession by Jefferson, fired his taser at the gasoline-soaked man, causing him to burst into flames. Okay, this does not necessarily strike me as the most reasonable course of action in the situation. The pepper spray thing seemed pretty good. Or maybe we could use some sort of blinding light. A lot of flashlights have some sort of strobe mode. That could be good to distract him. Or we could even use like tear gas maybe. That might work. But what we have instead is if you tase him, it will set him on fire. I see him dousing himself in gasoline. And then we have two officers who decide at the same time, roughly, to fire their taser into this guy, causing him to engulf himself in the fire. Fun. So, Corporal Ray and Officer Scott arrived at the scene around this time. When they entered the house, they found Olivia's engulfed in flames. The fire spread from Olivia's to the walls of the bedroom, and the house eventually burned to the ground. From the gasoline. The officers at the scene were able to evacuate the family members, but Olivia's was badly burned and later died of his injuries. So he's threatening to kill himself and burn the house down. And thanks in no small part to the assistance of the police, mission accomplished. That's just great work, police. That's super fun. Okie doke. Olivia's wife and son subsequently brought suit against the officers under 1983, a statute we know and love. Well, we know it at least. Loving is debatable at best. Against Sergeant Jefferson, Officer Guadalajara, and the city of Arlington, Texas, alleging defendant officers violated his Fourth Amendment rights when they tased him. Guadalajara and Jefferson each raised qualified immunity because, of course they did, as a defense, and moved for dismissal because of failure to state a claim. The district court denied the motion, finding more factual development was needed. So the district court said, no, we're going to keep this thing going because we need some more facts. Okie doke, Guadalajara and Jefferson filed a joint notice of appeal and then a motion for reconsideration. Because filing the notice of appeal deprived the district court of jurisdiction, it denied the officer's motion for reconsideration. Yeah, once you appeal it, it's not before the court anymore. So they can't consider your motion. Right. The district court then denied the motion on the merits. And now they filed this appeal. So the district court says, I'm not sure about this qualified immunity thing. Maybe we need some more facts. Maybe we need to look into this a little bit more and figure out whether these police officers were plainly incompetent or not. What does the Court of Appeals have to say? Well, let's find out. The district court reviews from the very beginning a denial of motion to dismiss pursuant to failure to state a claim. The court accepts all well-pleaded facts as true, viewing in the light most favorable to the plaintiff. This is a standard we know and love, right? We view this from the point of view of the people who are suing the police. Everything they say is true because that's how this works. The court reviews appeals of qualified immunity from the very beginning. When they invoke qualified immunity, the burden is on the plaintiff to demonstrate the inapplicability of the defense. Okie doke. Government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Who could have possibly known that causing a suspect to burn into flames is bad? Because qualified immunity is immunity from suit, not a mere defense to liability, it is effectively lost if it's erroneously permitted to go to trial. It is for this reason that denial of qualified immunity is immediately appealable, and the defendant's entitlement to qualified immunity should be determined at the earliest possible stage of litigation. This scheme, and I like how they refer to it as scheme, this word isn't meant negatively here, but still, we can read it with a little bit more negativity in the situation. Anyway, the scheme prevents a defendant entitled to immunity from being compelled to bear the cost of discovery and other pre-trial burdens, because heaven forbid the police have to explain themselves in any way. The qualified immunity analysis has two components, and you should be able to recite this from memory at this point if you've been following this channel for any length of time. So sing it along with me. Whether the plaintiff alleges or shows the violation of a federal constitutional or statutory right, and whether the right was clearly established at the time of the violation. Since Pearson, a reviewing court may tackle these questions in whatever order it deems. The second question, addressing whether a right was clearly established, encompasses another question, discussed separately in some courts' opinions, about objective reasonableness of a defendant's conduct. Which seems like a reasonable thing to do. Let's look at this objectively. And figure out whether this is in the scope of things a reasonable person could do. That seems like a good idea. And as I've pointed out before on other streams and other videos, there are many potential reasonable options, and I've stated a few of them already. We could do some tear gas maybe, or pepper spray was a good idea, or some sort of strobing light, or maybe sound that's too painful so he'll leave, or we could just tackle the guy. These are just a few of options that I'm coming off the top of my head. And there might be other options that you've dreamed up off the top of your head. So it's not like there's only one reasonable thing to do. There's probably many reasonable things to do. The question is, or maybe better said, maybe it should be the question, is this in the scope of reasonable things? Is this one of the reasonable options? So some courts ask that question, is this one of the reasonable options? The reasonableness of an official's conduct and degree to which the right was established. I never really heard that phrase, by the way. I'm not sure. The degree to which it's clearly established. How can there be a degree of clearly established? Isn't that kind of an on-off thing? Whatever. Are thus merged into one issue for the purposes of qualified immunity analysis. We now turn to the first prong of qualified immunity. The plaintiffs allege that Guadalajara and Jefferson violated the Fourth Amendment rights by use of excessive force when they fired their tasers at the gasoline-soaked guy. The question is thus whether Olivius had a constitutional right not to be tased while soaked in gasoline. Not as a general proposition, but under the particular circumstances present in the case of being soaked in gasoline. The plaintiffs had the burden of showing that this right existed and was clearly established. Okie doke. The Fourth Amendment protects individuals from being subjected to excessive force when they're physically apprehended or subdued by agents of the government. The question of what is excessive is thus intertwined with the issue of reasonableness. That seems like a good place to start. If it's reasonable, it's probably not excessive. And if it's excessive, it's probably not reasonable. So yeah, looking at it from a position of reasonableness seems like a reasonable thing to do, for lack of a better word. To establish the use of excessive force, a plaintiff must prove the following. Injury, which presumably in this case would be the being set on fire, which resulted directly and only from the force that was clearly excessive, and the excessiveness of which was clearly unconstitutional, clearly unreasonable. So we have to determine if it's clearly unreasonable, not just unreasonable, mind you, but clearly unreasonable. Okie doke. We now turn to those to address these elements that apply. Here, the plaintiff can easily show injury. Olivius died. Well, that's true, but a little bit underselling it. He was engulfed in flames after being hit with a taser, being gasoline soaked. And he didn't die immediately. He died later. So, probably not the least painful way to go, one would imagine. So saying he's died is somewhat underselling it here. And the house was destroyed. Next, we must ask where Guadalmar or Jefferson employed excessive force. We view disputed facts in the light most favorable to the plaintiffs. Right. You view them from the point of view of the person who's not asking for the dismissal. So we're going to believe everything that the family tells us, because that's how this works. Guadalmar, Jefferson, and Elliot, well, unless it's plainly palpably unreasonable, but, we don't have to worry about that right now. Guadalmar, Jefferson, and Elliot arrived at the house in response to a 911 call, having been told that Olivius was threatening to kill himself and burn down the house. This is information they had available to them. They found Olivius in a bedroom that smelled of gasoline. Further information available to them. Olivius was holding a gas can. Officer Elliot shouted, "If we tase him, he's going to light on fire." So we could also view this subjectively if we wanted to, although normally we don't do that in this situation. But if we were so inclined, we could also view it this subjectively, not just objectively. And what is their subjective knowledge state? Well, their subjective knowledge state is he's soaked in gasoline, because they said he's soaked in gasoline. So we know what they thought, right? So how can we know what's going through their mind? They told us. So we know their subjective state if we're interested in that too. Elliot then discharged his pepper spray at Olivius, temporarily blinding him, which would be a reasonable course of action. Then maybe, for example, you could try to tackle him, or the light thing, or sound, or any number of other options. There's probably other options here. Olivius began to shout nonsense and yell he was going to burn the place to the ground. He poured gasoline over himself. Maybe as he was doing this, you could tackle him. That's a good idea. As he's raising the gas can to put over himself, maybe that would be a good opportunity to tackle him. Just a suggestion. I don't know. It seems like a plan. At some point before either taser was discharged, the officers noticed an object in the hand that appeared to be a lighter. Guadalmar fired his taser, striking Olivius in the chest. Olivius burst into flames. Jefferson then fired his taser, which also struck Olivius in the chest, Olivius bursting into flames. I'm not sure if that's exactly the order, nor do I think it matters. Does it really matter if the one officer fired first or the other, or they fired at the same time? I don't think so. Probably not. It's probably too fast for the order to matter, right? Because there's no ability to perceive at the time. There's no ability to perceive it. So I don't know for sure, but I'm just guessing that things happen so fast that even if one technically was first, it was so fast, there's no ability to perceive it. But yeah, I don't know it really matters that much either way, but okay. Having set forth this factual background, so these are the facts, ladies and gentlemen of the jury. These are the facts. We now consider the reasonableness of the force that's employed. That's a good plan. Graham sets forth a specific factor that's to be considered: the severity of the crime at issue, whether the suspect poses an imminent threat to the safety of officer or others, and whether he's actively resisting arrest or attempting to arrest by flight. Here, the severity of the threatened crime, felony arson, was considerable. Yeah, other people are in the home too, so there's a threat to life there, not only his own, but other people, because other people are in the house at the time. Olivius posed a substantial and immediate risk of death or serious bodily injury to himself and everyone in the house. I think we concede that much. He was covered in gasoline. He'd been threatening to kill himself and burn down the house. He appeared to be holding a lighter. Well, that's You know, yes, at one point that's true, but we could back up the timeline a little bit and say there are things that happened before that. He didn't have to be holding a lighter, is my point. This fact doesn't need to be here because there could have been an intervention at some point that didn't happen. But alas, no. So at the point he's holding a lighter, there are at least 6 other people in the house, all of whom are in danger. This is true. The final grand factor in the reasonableness inquiry is whether Olivius was attempting to flee or evade, which is minimal relevance. I guess that's a question I've never considered before. Does it qualify as evading or fleeing arrest if the method of you fleeing or evading arrest is setting yourself on fire? I guess that's one way of evading arrest, but I never really thought about it on a technical level. Is it on a technical level, does that qualify as either evading or fleeing, setting yourself on fire to avoid the arrest? I don't know. These are questions I had never considered before. Okie doke. Arguing the officer's conduct was unreasonable. Plaintiffs cite a number of cases, also like basic logic and common sense, most of which are unpublished or not from the circuit. I don't think there's probably a lot of setting the guy on fire with the taser cases, I would guess. Although true that use of a taser in unwarranted circumstances can be unconstitutional, the facts of this case do not resemble those of whatever or whatever, the only published Fifth Circuit cases cited by the plaintiff. Samples involved the tasing of apparently intoxicated man who supposedly had growled at the officer and adopted a fighting stance. There's a little bit of difference in tasing someone who's drunk versus someone who's currently doused in gasoline. I'm not saying that tasing the drunk guy was reasonable, so don't misunderstand. I'm saying that those are kind of different things, in my humble opinion. Not quite in the same category. So regardless of whether tasing someone who's drunk is reasonable or not, I don't think really reads that much onto our present situation, but okay. Newman involved an arrestee who was tased after getting into an altercation while he's being patted down. Again, not our circumstance, not comparable in my opinion. Given the degree of granularity involved in the qualified immunity analysis, we see no reason to engage in a detailed discussion. That's perfectly fair, as we know all too well for our qualified immunity analysis. We know this all too well, because we cover a disturbing number of qualified immunity cases on this channel. I'm not quite sure how this channel became the qualified immunity channel, but apparently that's a thing that happened, because a substantial percentage of our cases are qualified immunity. So we know all together, we know collectively, that for something to be clearly established, it has to be really on point. Really on point. Sometimes really disturbingly closely on point. How close does a case have to be? Real close. Are either of these cases close? Not even remotely, given the standards we're talking about. No. So, no, we don't really have to discuss them in any depth because I agree. They're completely unlike the situation. And especially for qualified immunity analysis, we can chuck those right in the garbage, so that's fine. The only commonality they share with the instant case is that the police officers used tasers under arguably much more legitimate circumstances. Certainly neither involved a suicidal individual, flammable material. That is a critical factual difference here. That is a pretty critical difference. The flammable material is kind of notable. A credible threat of arson or the potential of immolation of others. Plaintiff also cites extensively to an unpublished case. In this unpublished case, this court reversed a grant of qualified immunity. It does occasionally happen. Not often, but it does occasionally happen. And whenever it happens, the qualified immunity is denied. We cheer a little bit because of how rare it is. Police officers had tased a juvenile who was running away from them, saying that they believe she might run into oncoming traffic. As an unpublished case, this is persuasive authority only. Fair enough. And we find it unpersuasive because it bears minimal relevance. Again, yeah, whether or not tasing a juvenile to prevent them from running into traffic, kind of different. For example, the person in that case had at most committed a minor misdemeanor infraction. She had not threatened to harm herself or anyone else. Except for the running into traffic thing, but okay. There's no particular reason to think she would run into the street. By contrast, Olivius over here was credibly threatening to kill himself and feloniously burned down the house containing at least 6 other people. Yes. And the room smelled of gasoline, which suggests that gasoline might be on the floor or something, or on him already. And now we've seen him pour himself gasoline on top of himself. We now turn to the officer's argument that their conduct did not violate any rights of Olivia's, or at least violated no right where existence was clearly established at the time of the incidents. Guatemala cites a number of cases in which police officers employed deadly force in somewhat comparable situations, and which this court found no constitutional violation. Yeah, I mean, I don't know if that holds or not as a logical proposition. Again, these are questions I hadn't really thought about before, which is one of the reasons I love doing this channel so much, because it means I get to consider questions I haven't considered before, and that's lots of fun for me. So is it possible simultaneously to say that, for example, shooting him would not be unreasonable, but using a taser would be unreasonable because of the particular facts here? I mean, that's a bit of a strange conclusion to draw, normally, because normally in your force escalation chart, right, gun kind of comes at the end of the chart. You don't normally in your force escalation chart think of taser as more severe than gun. Right? That isn't the normal hierarchy of these things. But under this particular circumstance, is it possible to conclude that a gun is actually less severe than a taser? It might be. I don't know if I've ever had that problem before. So it makes you consider something. It's like, is it possible for a gun to not be unreasonable and the taser to be, is it possible for the gun to be reasonable and the taser not to be the taser not to be unreasonable? Is that possible? Interesting questions, right? Makes you think a little bit. I mean, shooting would be a whole lot safer, as someone in chat points out. Yeah. Guatemala cites a number of cases in which police officers employed deadly force in somewhat comparable circumstances. Examples include whatever, finding no constitutional violation where officers shot an allegedly suicidal individual who had been ordered multiple times to drop a gun he was carrying while walking to his kitchen. Again, that's a little bit factually different than our current situation. I mean, what's reasonable and what's unreasonable is necessarily going to vary quite a lot on the circumstances of the situation, as one would expect, in the scope of what is reasonable and unreasonable. So is shooting a guy who's suicidal while he's carrying a gun walking to the kitchen reasonable, or at least, I mean, we don't know enough, right? Because we just have like the one line. So we don't have enough information. But it doesn't strike us as palpably unreasonable. At least it doesn't strike me as palpably unreasonable. I mean, he does have a gun. He's a threat to people, not only himself. So maybe, you know. A different case, finding no constitutional violation where officers responding to an ex-wife's 911 call, stating she feared her ex-husband may have taken overdose of sleeping pills, breached the door and shot him when he raised a knife over his head and advanced towards them. Again, that seems like, at least based on the one-line description, seems like a potentially reasonable thing to do. Maybe the facts of the case are not quite as clear as suggested here, but the guy is approaching the officers with a knife in hand. Shooting him may be a reasonable course of action under that factual predicate. And a different case, finding no constitutional violations where officers breach an allegedly suicidal individual's bedroom door and shot him after he attacked them with the knives. So we have two different knife suicide guys. So, yeah, okay. The cited cases recognize the principle that the use of deadly force is constitutional when the suspect poses a threat of serious physical harm to the officers or others. Yeah. I mean, yes. But, yeah. Plaintiffs refer us to case law purportedly establishing that deadly force may not be employed against individuals threatening only themselves. I'll take your word for it. This discussion, however, is not apropos. Olivius may not have only been threatening himself, but was threatening others in a way that put everyone in the house, and possibly others beyond that, in danger, which is fair, because fires can spread and so forth and so on. Which is a pretty good reason not to use tasers, especially when you know they're going to cause a fire from gasoline. Maybe not the greatest plan. Although the employment of tasers led to a tragic outcome, such as the burning of the house and the guy being burned to death, we cannot suggest exactly what alternate course the defendant officers should have followed, which would lead to an outcome free of potential tragedy. Okay. Let's read that again and see if we agree. Although the employment of tasers led to a tragic outcome, we cannot suggest exactly what alternative course the defendant officers should have followed that would have led to an outcome free of potential tragedy. I've suggested some ideas, and I think you and chat have probably suggested some ideas too. Can we think of anything that might have avoided the tragedy of the guy being burned alive and the house being set on fire? Can we think of anything? Again, putting ourselves in the position of the officers at the time, because as the court is about to explain to us in 3 seconds, we don't do the hindsight thing. We can only rely on what we know. We can only rely on what we know. So, But what do we know? We know that he's a threat to himself. We know he's threatened to burn the house down. We know the room smells of gasoline. We know that he's poured gasoline on himself. We know that using a taser will start a fire because, one of our officers said that, like, just now. We can't think of anything that they could have done differently in this situation? Okay. We emphasize that reasonableness of a government official's use of force must be judged from the perspective of a reasonable officer on the scene, not with the benefit of 20/20 hindsight. Very true. We can't do hindsight. That's unfair to everybody. We can only put ourselves in the position at the time. The fact that Olivius appeared to have the capability of setting himself on fire in an instant justifies us setting him on fire. And indeed was threatening to do so meant the officers had no apparent options to avoid the calamity. Okay, I guess my imagination's better than the court's, I guess. I don't know. If reviewing the facts in hindsight, it's still not apparent what might have been done differently. Really? To achieve a better outcome under the circumstances, then certainly we, who are separated from the moment by more than 3 years, cannot conclude that Guadarrama or Jefferson, in the exigencies of the moment, acted unreasonably. So even 3 years later, with all the benefit of hindsight and thinking, the federal judges can't think of anything that they could have done differently. I've been streaming this for 34 minutes. I didn't read it in advance. I've thought of some ideas. And they can't think of anything? So I guess our new game show is, are you smarter than a federal judge? Apparently, the answer to that question is somehow yes. Who knew? While the preceding discussion applies to both officers, we must distinguish between the officers' conduct. Okie doke. Given that Guadarrama fired first, the most readily apparent justification for his use of the taser was to prevent him from lighting himself on fire. Okay. So the court thinks the purpose of the use of the taser was to prevent himself to prevent this guy from setting himself on fire. That was the point. But the officer knows that using the taser will set himself on fire. You see the problem here? You see the problem? The court thinks he's using a taser to prevent the guy from setting himself on fire. But the officer knows that using a taser will set the guy on fire. So this is literally burning down the village to save it. Or even more literally, burning down the village to prevent it from burning. Okay. Jefferson fired second, and at one point claimed to have fired instinctively. Plaintiffs allege that he did so intentionally, and because we're viewing this from their point of view, he did it intentionally, because that's how this works. Accepting that he did it intentionally, because that's the law here, right? Jefferson still had good reason to try to immobilize him, namely, to prevent him from spreading fire around the house. Let me use a taser, which I know will start a fire, to prevent fires from being spread around the house. I don't know, man. The court apparently is writing this with a straight face. The court doesn't seem to see any problem with this. We see no problem with we see no problem with lighting the guy on fire to prevent himself from lighting him on fire, and we see no problem from lighting the room on fire to prevent the room from being set on fire. This is in the course of reasonableness somehow, or at least it's not clearly unreasonable. Moreover, at this point, there's no risk that using a taser might ignite a fire since he was already engulfed in flames. Well, we feel a whole ton better, I guess. It's okay because he couldn't set him on fire because he was already on fire. Accepting these facts as true and construing them in the light most favorable to the plaintiff, neither officer's conduct was unreasonable, nor was the force clearly excessive. We thus find the factual allegations do not make out a violation of the Fourth Amendment rights. I don't know. Once again, every situation has to be considered on its own merits. And we have to consider the facts that are most pertinent to every situation to consider what is and is not reasonable. And what's fully reasonable in one situation may not be reasonable in another situation. And even things that are lesser might be more in a given situation, because that's how reality works, right? Something that's innocuous in one situation might be fatal in another. I mean, we can all dream of scenarios, right? And something that's fatal in one scenario might be innocuous in another. And therefore, what is reasonable might change depending on the reality of the time. And so it might be prudent for us to consider all the facts that are relevant as we consider what is and is not relevant, or what is and is not reasonable. And as I've taken some pains to point out, there can be a wide range of reasonable options under circumstances. There's not necessarily one only reasonable thing. And different people can even have different boundaries about what's reasonable. All that being said, however, I'm having a bit of difficulty with, I know the taser will set him on fire, so I'm going to use the taser to prevent him from being on fire as a reasonable course of action. There seems to be some tension there. Seems to be some tension from, I'm going to set him on fire to prevent him from being set on fire. There seems to be some conflict in my mind. Maybe you think about it differently. The court does. The plaintiffs have asserted that the officers violated the Fourth Amendment rights of their deceased husband and father by using excessive and unreasonable force causing his death. A particularly painful one would note. The officers have invoked qualified immunity because of course they did, arguing there's no constitutional violation because their use of force was reasonable under the circumstances. I don't know. I'm not sure that I can, in my humble opinion, necessarily agree that this falls in the category of reasonable under the circumstances. Reasonable in many circumstances, yes. Reasonable in these particular circumstances, I'm not 100% sold on that proposition at this point. We have found that, given the horrendous scene the officers were facing, involving the immediate potential for destruction of lives and property by fire, the force firing tasers on a guy soaked in gasoline in an environment where there are gasoline fumes was not unreasonable or excessive, and consequently we hold the officers did not violate the Fourth Amendment and thus are entitled to qualified immunity. For the reasons given, we reverse the order of the district court denying qualified immunity and remand for dismissal. Thus, that brings us to the end of the discussion of the case of Selena Marie Ramirez versus Jeremiah Squadamara and Ebony Jefferson. In this case, two police officers at least, more than that, but two police officers were involved. Some police officers show up to a scene. The guy is in his house. He's threatening to set himself on fire, or at least the building on fire, threatening to kill himself. The officers show up. The room smells of gasoline. Gasoline fumes are in the air. The officer says, if we use a taser, it's going to cause a fire. They then see the guy douse himself in gasoline. They then see him with a lighter in hand. And I guess they decide that, if anyone's going to set him on fire, it's going to be us. And to prevent him from using this Zippo lighter or whatever to set himself on fire, we're going to use our tasers to set him on fire. And the court says, well, first of all, there's no case on point, which I believe because this is ridiculous, right? And second of all, they say this is reasonable under the circumstances. We can't think of anything differently they could have done. Okay. I mean, all right. I don't know what to tell you. That's the end of that case. So, as always, if you're enjoying this, please remember to like it. If you're not subscribed already, please give us a subscribe. And did you know for 99 cents, you can become a member of the channel? It's true. You can hit the button that lets you become a member and helps support the channel financially. And until later, my friends, cheers and goodbye.